Hi, this is Zach Haptonstall, CEO and co-founder of Rise 48 Equity. At Rise 48, we partner with investors like you to purchase large apartment buildings that we renovate to increase the value and create a profit margin for our investors through monthly passive cash flow distributions and profits on sale. We're a vertically integrated company specializing in the Phoenix, Arizona, and Dallas, Texas markets with over 200 plus full-time W-2 employees who are focused on making sure your investment is taken care of. To learn more about Rise 48 Equity's multifamily investments, schedule a call with me at rise48equity.com/invest.
There's like millions and millions and tens of millions of LLCs out there that are active. So just imagine all of those LLCs, all those people flooding a government website to make sure that it gets filed. So I would not be shocked that that system will get overwhelmed, where it might crash, or you might not be able to get in, and you're trying to. So that's why I encourage you guys to get on this early.
Hello, left fielders. Welcome to the Passive Investing from Left Field podcast. Our community is focused on networking and education to help people invest passively and think differently. Let's go.
This is MC Lobsher from Cashflow Ninja, and you're listening to the Passive Investing from Left Field podcast.
Happy New Year, left field investors. We are starting something new. We plan to have 1 or 2 shorter episodes each month focusing on a specific topic, and these will be released on Wednesdays. This is the first of those episodes, and we are going to talk about the Corporate Transparency Act, the CTA. It went into effect just a couple of days ago on January 1st, and it will impact almost everyone who is a part owner or full owner of an LLC. We are fortunate to have the premier syndication attorney and former asset protection attorney, Mauricio Rauld, with us today to give us all the details about what we need to do to be compliant for this new law. Mauricio is the founder of Premier Law Group and specializes in syndications. He's also one of the co-hosts of one of our community's favorite podcasts, Drunk Real Estate. Mauricio was also a guest on episode 134 of Passive Investing from Left Field, released back in September of 2023, so please check that out. Mauricio, welcome to the Passive Investing from Left Field podcast.
Hey, thanks for having me, Jim. Looking forward to this.
Yeah, excellent. So just please give us a brief introduction of who you are and what you do, remembering that people go back to episode 134 if they want the full boat, but just a brief intro here would be great.
Yeah, so I'm an attorney, man. Please don't hold that against me. I'm actually a pretty normal guy. I'm usually referred to as the anti-lawyer because I'm not your typical attorney, but most of the time I'm representing syndicator sponsors. I help syndicators stay out of jail, so to speak. So I'm in charge of making sure they're raising capital in full compliance with federal securities laws, primarily to protect the limited partners. So I know your audience is limited partners. So my job is really to protect the limited partners and therefore protect my clients as well. And I'm also a recovering asset protection attorney. So I've set up probably thousands of LLCs over the past 15, 20 years or what have you. And so I'm really well versed in that, even though I don't necessarily specialize that in anymore. I've got the whole LLC formation and asset protection and entity formations pretty dialed.
Excellent. And that is why we have part of the reason we have you on today. We're going to talk about the Corporate Transparency Act. So let's just jump in. What is this? What is the CTA?
Man, it is quite a piece of legislation. So this is a piece of legislation that effectively will affect anybody who has some type of entity, whether it's an LLC, a limited partnership, a corporation, an S corp, any of those things that you actually file. It's a new legislation that essentially will require you to provide the government with certain personal information so that they can figure out who you are, that you're not nefarious, that you're not a terrorist, that you're not trying to, hide stuff, that you're not, money laundering. And so they've passed this law that goes into effect January 1st of 2024 that essentially will take care of all that stuff. So you're no longer going to be able to, quote unquote, hide behind your entities or be anonymous as it relates to the government anyway. So they know who you are, what nefarious activities you're up to.
Okay. So now you mentioned the government would find out about it. So if I have a Wyoming or Delaware LLC, the government will know who I am, but it will be still protected and hidden from other people.
Yeah, that's a great point, because that was the number one question I get is, privacy is such a big piece of the asset protection, right? That's one of my 6 layers. And so I really am a big believer in privacy. This will throw out the privacy as it goes to the government. But yes, a private enterprise, if you get into a car accident or somebody's looking to sue you, there's a plaintiff's lawyer digging around. in theory anyway, according to the legislation, they're not going to be able to get access, similar to your tax returns, right? Your tax returns are not something that the government knows about your taxes, but it's not something you can easily get to. And I think the same idea is going with the Corporate Transparency Act.
Okay. And then you mentioned that it's pretty much going to affect everybody who's LLC owner, but can you explain what the reporting company is and how that relates to a beneficial owner? Because those are two different things. And if I'm both, do I report twice?
Yeah, so there's actually three sets of categories of people or entities that are affected, right? Number one is the actual, you mentioned the reporting company, meaning what's the LLC itself or the corporation itself that filed with the Wyoming Secretary of State or Texas Secretary of State. So the entity the reporting company is somebody that has to comply with this rule, and they've got to provide certain information to the government. And for those, it's pretty straightforward. What's the name of the LLC? Is there a DBA? Where is it domicile? Where was it registered to be set up? And what's the address? And then what's sort of usually an EIN or some corporate identification number. And again, most of the time it's going to be the employer identification number, but it can be other things like, each entity has a corporate entity name from the state. So anything that identifies that entity. So that's one of the categories. So the LLC itself, just say it's LLC. When I say LLC, I'm talking about entities in general, but let's just call it an LLC because most people, I would say 80-90% of people really have LLCs. So the LLC itself has to file. Then all of the quote unquote beneficial owners of the LLC or the entity also need to file their personal information with the government. Now, this is where it gets a little tricky because what does beneficial owner mean? And ultimately what the government's trying to do is try and set up a scheme where there's no way you can get around this, right? If you're the ultimate owner, you can't say, well, my owner's really an LLC or my trust or or I've got, I don't even own it. I've got a profit sharing agreement, like whatever it means. They're trying to catch everyone. So essentially what a beneficial owner means is one of two things. Either one, you own 25% or more of the entity. So if you own 25% or more, you're a beneficial owner. So if it's just you or you and one partner or you and your spouse, you're a beneficial owner. Or anyone who has basically substantial control over that entity. So the manager, the co-managers, or even if you're not the manager, but you have a majority voting stake, right? If although you probably get caught up there on the other side too. But if you have control, like you have the ability to hire and fire the manager because you're out over here and you have the special powers, even though you may only own 1% of the company, but you have 56% of the shares, voting shares, you're going to be somebody who has substantial control over the entity. And so you would also be required to provide your personal information, which we can get to in a second. And then the third group of people, which is more applicable to people like me, not necessarily you guys, is just whoever actually files it. So me as the filer, and again, I've filed over 1,000 of these, the filer, whether it's LegalZoom or your attorney or us, those are also, I have an obligation to provide information to government as the person who is filing the LLC itself.
So the information that actually needs to be filed, you mentioned, it's really just some basic info. It's nothing too deep, right? It's an EIN, some other information. I mean, that's all. It sounds simple, right?
Yeah. So that's for the corporation or the entity. The entity I think is pretty, where I think some people are going to get, all wound up about it is on the personal side. So they're ultimately trying to get to the ultimate owner. So eventually it's going to get to an individual, right? It's not going to be, even if the beneficial owner is an LLC, then we're going to see, well, who's the beneficial owner of the LLC or who has control over that LLC. So eventually we're going to get to individuals, right? So if I am now a beneficial owner, Mauricio, I'm going to have to give them, number one, my name, my full legal name. Number two, my home address, not a PO box, not my business, my home residential address. Number three, my date of birth. And number four, another identifier number. So driver's license, passport number, whatever number, official government number identifies me with them. And a copy of that, the front page. So a copy of my driver's license needs to be uploaded, or if I'm using my passport, upload a copy of my passport up to this platform. And that'll then satisfy my requirements. Now, the good news is that if I'm somebody who, like a syndicate of my clients or even an LP LP probably wouldn't be caught up in that, but somebody who's just constantly, filing entities. I've got 20 entities. I file 2 or 3 or 4 entities every year. Then there's going to be a shortcut for you because you're going to be able to get a sort of an identification number. So you upload everything once, you get that identification number, and then you're allowed to use that identification number for the following one. So ideally, at least in theory, it's going to be the first time is going to be kind of the mass upload everything. But once they have that, if you want, you can request a special identifier number that you can use in the future.
Okay, excellent. And when does this need to be filed? As I understand it, for any new LLC in 2024, this is just going to be part of the registration process. But, we've got all kinds of LLCs that are, prior to 2024. Can you tell us what we do with the old ones and how we do the new ones?
Yep. So they're all going to be divided as pre-January 1st, 2024 and post-January 1st, 2024. Anything pre, right? So everything that you have filed or owned that is active. Remember, these are entities. You may have set up this entity 25 years ago and you have a rental property in there and you still have the rental property. That counts, right? I mean, there are clients of mine that have literally over 100 LLCs because they have a lot of properties and a lot of deals. And so any active business that's been in existence before January 1st, you're going to have 1 year, basically till the end of 2024, right? So technically January 1st of 2025, although I always say that's the holiday. So it's going to be December 31st of 2024. But you have 1 year to comply with all this regulatory stuff, right? So that gives you some time. Highly recommend you don't wait till the end, but at least start thinking about it. But you've got a little bit of breathing room. And if you've got one or two, it's not a big deal. But like I said, one of my clients had 117 of them. And so we got to work through 117 LLCs to get compliant on this stuff. And then if you filed it starting January 1st of 2024, so in 2024 into the future, moving forward, you're going to have to file this within 90 days. Now, I know we're going to give out a report, and that report said 30 days, but they recently, since that report, this is like cutting edge, Jim. This is now. The FinCEN, which is a financial network, crimes enforcement network, just updated that to 90. Primarily, I think, because they don't have their act together. So I'm not sure they're going to be ready to do this in 30 days. But now, so you're going to file an LLC. So let's say you file an LLC on January 20th. You're going to have 90 days from January 20th to comply with this. Or if you file something in August of 2024, you're going to have 90 days from August to file all of this information with a portal. So FinCEN, which is the governmental agency, the Financial Crimes Enforcement Network, will set up, because it's not there yet, even though we should be there. They set up something called BOSS, a beneficial owner safe system or secure system. I forget the acronym, but BOSS. And that's the website or portal that you're going to be entering all of your information and then uploading the documents that you need to upload, the driver's license, the EIN number, the passports, all that stuff through the BOSS system. Now, again, I should have the stats, Jim. I apologize, but I know there's like millions and millions and tens of millions of LLCs out there that are active. So just imagine all of those LLCs, all those people flooding a government website to make sure that it gets filed. So I would not be shocked that system will get overwhelmed, where it might crash or you might not be able to get in, and you're trying to. So that's why I encourage you guys to get on this early, because if not, that might be a concern. One other thing about timing is any changes, right? So any amendments that you have from the time that you set up the LLC. So let's say there's now a new manager, or maybe one of your investors leave, making you go from 20% to 26%. So now suddenly you get caught into it. You have 30 days to amend any filing you've done, right? Because again, sometimes, especially in my world, you'll have two co-managers of an LLC, and then maybe you add a third. Well, now that person's going to be a beneficial owner, and so we have to amend. And that's where it gets tricky, because the obligation is on the entity itself, and that's all the beneficial owners to file. And who's going to do that? Is it the manager? Who's the designated person who's responsible? And if they don't do it, and you get caught up in that. So there's some best practices that I'm actually working through. I'll probably release a video, or maybe we can come back and talk about it as well, like best practices in terms of like amending operating agreements to specify, look, you're going to be Jim, you're the guy in charge of making sure we're compliant with this thing. And if you screw up, and if you you're going to indemnify me, because you're the one who's responsible for updating this information. And if you don't, I don't want to get on the hook, because as you know from the report, the penalties are pretty high. They're pretty egregious, honestly. That's probably one of the more interesting factors is what the penalties are for noncompliance, because the government isn't messing around.
Yeah, well, let's talk about the penalties then. What are we up for if we skip out on this?
Yeah, so if you just the regular fine, right, on the civil side, which is no jail time there, but on the civil side, it's $500 per day. Right. And it's going to be per entity. Right. So Very similar. I don't know if you guys know, but if you have international, it's very similar to when you have international companies or international bank accounts. You have all these requirements to file and let the government know you have these. And the penalties there are about $10,000 a day. So here it's only $500 a day, maximum 10 grand. But on the criminal side, you can get up to jail time, up to 2 years in prison if you do. Now, I don't know if that means I can't imagine if you miss it for a day, you're going to end up in jail for 2 years. But if you continually insist and you pass the deadline, and I'm sure they'll send you reminders, and at some point it gets to the point where it's criminal, then you're going to have 2 years. Now, if you're intentionally doing this, the number can go up as high as $250,000 and up to 5 years of imprisonment. I think that's if you're intentionally defrauding or intentionally trying to get around the rules. Maybe, my guess is, and again, we don't know, but my guess is you're providing wrong information intentionally because you don't want to reveal your home address, and you're uploading fake documents. I mean, the penalties are egregious. You really don't want to mess around with this stuff. The government's obviously taking this very seriously, whether we agree with it or not, or whether we think it's a violation of our privacy or not. They're going to take it seriously. It's going to be interesting to see, how aggressive they go after the people who violate it. Because remember, ignorance of the law. I was having this discussion because I talked about this on our podcast. We have a podcast called Drunk Real Estate, and Jay Scott, one of our co-hosts, he's like, what if I don't know? I mean, I don't follow the news. I don't know anything about this. I don't know about this new requirement. Well, it kind of seems unfair that I get penalized because I didn't know that nobody told me. Right. And so it's ignorance of the law is not an excuse. So this is why I appreciate you. And I'm trying to put light into this, and folks like you and your podcast, Jim, your amazing podcast, helping folks become aware of this.
Yeah, this is a lot. So I think we've covered the basics. So now I have a couple of situational questions.
Yeah.
Let's say I'm in a LLC with 10 other people, and we all own 10%, right? So we're below the 25% threshold. The LLC has to file. So, one of us has to figure that out. So what do each of the members need to file, or are we exempt from filing as individuals because we own less than 10%?
The question I would ask you is, who's the manager? Right? Are they all managing? So usually there's one or two managers, right, of that 10. It's very rare that I see 10 managing members, right? So typically it'll be one manager, 2, 3 managers, 1 to 3. So those 3 would absolutely be a beneficial owner because they have significant control over the entity. And again, don't get caught up on ownership, because if one of those 10% owners happens to have a 51% voting for some reason, right? Because that's what happens, right? People trying, in order to avoid, this is what the government's thinking, in order to avoid these legislations or these laws in different countries, people play around. Like there's something called bearer shares, right? Where you literally, the owner of the company is the one that physically has the shares, right? But I have control. And so it's possible for somebody to say, look, I own 50%. I don't want to have to register. So let me just take 24.9%. But I'm going to have control. So even though I'm not on the paperwork as in control, I'm really at the end of the day in control. That's what they're trying to catch. So it doesn't really matter so much of the ownership is important, right? Because it's 25%. But if you have significant control, it is possible that you have 10% ownership, but significant control. And certainly the manager and the manager, the managers, those folks would absolutely have significant control, right? Because they dictate what can happen.
Okay, so in our community at Left Field Investors, we use a TribeVest. It's a group investing platform, and it allows us to just pool capital. So we might have a tribe with 12 people in it, and everybody has different ownership shares, but it's unlikely that anyone's over 25%. Yeah. And the manager is, sometimes TribeVest might be the manager, so maybe they're responsible for it. And other groups like that, like the 10% one I mentioned, everyone is kind of a manager, but maybe in the operating agreement, we picked randomly somebody would be president, someone would be vice president, just for the purpose of the operating agreement. But I feel like for those LLCs, if I'm in one of those, I want to just file the information, right? There's no downside to me saying, hey, here it is, right?
No, but yeah. So, it all goes back to this term significant control, right? So if there's a president and at the end of the day, they're going to, again, I don't know how deep they're going to do it, but if somebody's auditing your company and they're like, are all 10 of you always signing everything? And if you need to go to Costco and buy a pencil, do all 10 of you get in a car and go? Or is there's usually somebody, a president, a CEO, a VP or whatever, usually the manager, that has the significant day-to-day control. It's very rare that all 10. And so they'll just dig in. They're not going to care about the kind of the structure itself. They're going to look through that. It's very similar to our syndication world. They look through all the smoke and mirrors, and it's like, well, did somebody have significant control? There's got to be somebody. That doesn't have to be. If you can show that all 10 of you, every time there's a decision, all 10 of you got into a room and you voted, and everybody had 10% vote, and whatever the majority was went, then I think you've got a good argument there. But most of the time, that's not what happens. There's 1 or 2 or 3 managers, or 1 or 2 or 3 people that have significant control. Those individuals would have to then they become a beneficial owner and would have to report this to FinCEN.
Okay, and just to kind of dig in again, because we use a lot of TribeVest tribes, and those typically are, if each of us own 10%, we all vote on everything. All the decisions are made as a group. Now, someone might be in the operating agreement as an officer of the company, but these are all group decisions on the portal where we vote. It's clear that it's a group. So it seems to me that to be safe, I would want to register personally all of my tribe LLCs.
Yeah, I mean, there's always you could definitely be more conservative than needed. Like, so
Okay.
in my world, I'm usually talking to people who don't want to do it, right? But if you don't care and you're like, hey, I'd rather do it just to be safe, there's nothing that's going to prohibit you from doing it. I'm sure the government would love to get that information from you. But again, when you say on the operating agreement, there's an officer, I would take a close look at whoever that officer is, because if that person, is doing something without the approval of the other 10, that person may have significant control, and that individual may have to do it no matter what. But if all 10 of you say, look, I don't want to mess with it, I don't want to risk it, let's just put it in the operating agreement that we're all going to, do this. I haven't seen the website, so maybe it doesn't allow you. Maybe it says, hey, what percentage do you own? 10%. And they say, do you have significant control? No. And then maybe they block you and they don't allow you. We haven't seen it. It's not out yet. So we don't know what it looks like, not par for the course, right? So as soon as Boss is up and running, maybe we'll do some content on how it looks and how it works.
And so I'm investing in a lot of syndications, as are most of the people listening to this podcast. So I'm going to assume and get confirmation from you, those I don't have to worry about, because I don't own more than 25% of any of those, and I have zero control. So those are good, right?
100%. Like most syndications, investors are a separate class. And the reason they're in a separate class is because even if they own 30% of the company, they wouldn't have 30% control. And so I guess if they did own 30%, but even then it's like with the lenders, even if you own 30% of class A, right? If class A only owns 80%, it's an 80-20 split, then of the company, you're not going to own 25%, whatever the math is there. You're going to own 30% of 80, which I don't know what the numbers are, but yeah, I don't think LPs and syndications have much to worry about. I think it's more, in that one, it's going to be the sponsors, like who are the managers or the GPs, or who the GPs of the GPs. And then there's a special class B, that has all the significant control, who has who are those members. And again, they're going to be the sponsors. So I think sponsors are going to be definitely caught up in the net, most likely.
Okay. So let's talk about, somebody who's in maybe 12 TribeVest LLC tribes, and maybe has 5 or 6 other LLC entities that, they might be with a couple people, maybe one person, maybe 4 or 5. So I have, maybe 20 LLCs that I'm talking about. Do I just do that on my own, or is there somebody that can help me comply? And if there is someone who can help me comply, how much is that going to set me back if we've even gotten that far?
100%. You can definitely get people to comply, help you comply. We actually are doing that for our clients, and we're happy to do it for other people as well. But we like I said, I've said over 1,000 of these, and so I've got 1,000 clients. I don't know how many of those are active, but there are clients that are still out there. So we're doing that service. Most people I've checked with are charging somewhere between $200 and $250 for that compliance, as long as it's straightforward. Where it gets complicated, which we honestly don't know how long it's going to take. And so I think we're going to do the same thing as most, which is like, we'll do it for $200 or $250. And then anything, if it's complicated, we'll just probably do it an hourly rate. We're having paralegals do this. But, again, if you have an LLC and you own it, you and I own an LLC, Jim, pretty straightforward, right? But if there's an LLC and that's owned by another LLC, and that other LLC is owned by your holding company and my holding company, and then those holding companies are owned by our living trust, and then it starts to get layered, that gets messy. And so that's probably going to be an hourly rate, which is what I've called around. That's kind of the industry I think is going to happen. But you can reach out to us, and I'll tell you how to do that in a second, or just reach out to whoever set up your LLC to begin with. They most likely have either can do it in-house there, or they can refer you to somebody to do it. But we're happy to do it.
Excellent. This was fantastic information. It doesn't sound fun, but it's not as daunting as I thought when I first heard of this. It's just some basic information. I don't want to do it, but I will comply. I don't want to pay or go to jail. So is there anything else we need to know about this? And I'd love to hear where we can go to get this report, the Corporate Transparency Act, the report that you wrote. Can you give us that information?
Yeah. So you can, if you email CTA, which is for Corporate Transparency Act, CTA at plglp.com, plglp.com, because I'm with Premier Law Group. So CTA at plglp.com. We'll email that report to you. I've actually updated it already because the old report said 30 days. I think, Jim, that's the one you saw. Now it's been updated to 90 days, and we'll continue to update them. What's cool about that is if you get that report, what will happen is as new reports come in, or anything related to the Corporate Transparency Act, like for example, I'm working on best practices, like some of those questions you asked me, and I think people need to amend their operating agreements to address this. so that because there's liability issues. Every time we have new content about that, we'll include it to whoever's requested the reports. We'll have that list from you guys, and we'll make sure you guys are updated with all the new information as it comes along.
Excellent. Well, thank you very much. This was fantastic information. We really appreciate it. And Mauricio, we look forward to, I'll announce it right here. You're going to be one of the speakers at the Best Ever Conference for the Passive Investing with Left Field Day at the Best Ever Conference. So we're super excited. So if we don't talk to you before then, we'll definitely see you in April.
No, I'm looking forward to seeing you guys in April. And yeah, it's going to be a great event.
All right. Thanks a lot, Mauricio.
Thanks, Jim. Appreciate you, man.
Are you looking for a way to invest at a lower minimum and participate in more deals? Look no further than our weekly deal webinars hosted in collaboration with TribeVest. With every deal we offer, Left Field investors have the option to join an open tribe, allowing you to invest for as little as $10,000. No need to meet the standard $50,000 minimum. Joining an open tribe is easy. TribeVest handles all of the setup, fund collection, and distribution, and even provides K-1s for tax time. All you have to do is sign up. Stay up to date with LFI by subscribing to our emails and gaining Clubhouse access to join our deal webinars and open tribes. Don't miss out. Thanks for hanging out in the left field with us today. If you are interested in becoming a left fielder, you can find us on the World Wide Web at www.leftfieldinvestors.com and click the subscribe button to join our community. If you enjoyed the podcast, please subscribe to the show on your podcast player so you don't miss an episode. If you really enjoyed the show, a review on Apple Podcasts or wherever you listen to podcasts would be appreciated.
This show is for entertainment purposes only. Nothing said on the show should be considered financial advice. Before making any decisions, consult a professional. This show is copyrighted by Passive Investing from Left Field and Left Field Investors. Written permissions must be granted before syndication or rebroadcasting.